So if our esteemed first panel will start, I'm actually introducing this panel, but I guess they gave me a chair, so I don't know if I have to stay, but we'll see. Now you may notice in your program that it indicates that our moderator, the first panel, is Sarah Redfield. Unfortunately, Professor Redfield has had some illness in her family and she was unable to go. So we found a replacement. Many of you may have heard of this replacement. She's known around the country, around the world, and that's Judge Bernice. And I think we're in good hands because she knows a couple things or two about what we're talking about today. But our first panel today is Extending Justice, Strategies to Increase Inclusion and Reduce Bias. What exactly is this? This is essentially a compilation work that the members of this section have created. Judge Donald and Professor Redfield have essentially guided us through that path. And I see that Kim Parker actually has the book. Kim, would you like to show everyone what we're talking about? This book is absolutely amazing. I would urge all of you to consider purchasing the book. And after you hear from the panel, you'll see why. There are so many different perspectives and so many different issues covered that I feel all of you would find some value from it. But I won't belabor the point because you're going to figure this out for yourself after you hear from this panel. So I'm going to turn it over to Judge Donald, who will start us off in this conversation about extending justice.
Thank you, Mr. Chair. Good morning, Criminal Justice Section.
Good morning.
What an incredible time it is to be in this place, in this space, talking about this topic, and having this conversation after that tremendous keynote by the Honorable Kim Fox. What a power. And I know that you wear justice on your shoulders well, and you're still unbent and unbowed, and we salute you for your work. We have an incredible panel this morning to talk about this most important topic, and I want to start off by setting the stage. I want to tell you, when we talk about extending justice, we mean extending justice to all. We have those wonderful phrases that are inclusive, but somehow, as Kim mentioned, in many areas there are disproportionalities. And the blanket of justice doesn't fall evenly on all groups, but we have as our cause to make that happen and to continue to put our hands to the arc and bend it in the direction of justice, because that's what's required. Before I present the panel, I want to ask you to do something, because I have learned, having attended the National Judicial College, that with adults, we learn differently than younger students. We need interaction, we need to participate. So I want you to participate this morning. I'm not going to embarrass you. Now, because I don't have law enforcement in the room, law enforcement with guns, I'm not going to ask you what I would normally do, and that is to close your eyes. You can keep your eyes open. But I want you to stay with me and think and do what I ask you to do. I'm going to go through a list of categories very quickly. And I want you to remember what comes into your mind when I call these categories. I'm not going to ask you individually to tell me what came in there, but I am going to ask for a show of hands. And we have an energetic new member over there, Paula Edgar. She's going to be kind of watching, and I know she wouldn't mind playing along, but I'm not going to even ask her to do that. So what I'm going to ask you to do, remember, I'm going to go through the list very quickly, and then I'm going to ask, I want you to remember rather what came into your mind when I call these categories, and I'm going to ask for some shows of hands, okay? I'm a Southerner, so I've been practicing speaking rapidly, and I'm getting better. Here we go. All right. Here are the categories. I said we didn't have law enforcement in the room, but we have Chief Holloway. But he's. I'm not going to task him with protecting everybody this morning. I just want him to go along also. So here's the category.
Okay. He doesn't have a gun. So.
Yeah, he didn't bring the gun. Okay. Prostitute, doctor, airline pilot, lawyer, NFL quarterback, secretary, flight attendant, drug dealer, escort, CEO, nurse, American, defendant. Okay, that's the group. When I called out airline pilot, how many of you thought of a woman? Hands up. Okay, one. When I called out secretary, how many of you thought of a man? One. When I called out escort, don't tell me what you thought. But when I called out CEO, how many of you thought of an African American woman? Thank you. And when I called out defendant, how many of you thought of a white female? Okay, one. When I called out American, many of you probably just had a range, an array going across your minds, because we know that there is not one single image of an American. And we struggle sometimes with the blessings of liberty on all Americans, because we really don't have a clear picture of what an American looks like, because there is no one single profile. I had you go through that exercise because this gets at bias and our ability to equally extend justice, because we put people in categories, and there are deserving people and there are undeserving people. And many of you, and I'm not going to ask you this, but many of you had different images come in your mind when I called out prostitute as opposed to escort. So class plays a big role in this also. We're talking about getting into this subject matter and educating so that we can break down some of those silos, so that we can discard some of those stereotypes and really accord the same measure of justice to each and every individual. And it's not just in the criminal justice area, although that's what we're working. These stereotypes, these images cut across all groups and cultures in our country. Now with that, we have this wonderful book, which Kim is holding up again, and you can see that. And this book will be and is for purchase, but I want to just put that aside now, and there'll be flyers that will magically appear on the tables during the course of this presentation. But I want to start by telling you we have a star-studded dynamic panel this morning to talk about this, and we have a bench, because over at the table to my left, if we get in a pinch, Kim Fox and Justin Bingham, I'm sure will jump up and help us as we go and talk about this topic, as they're intimately aware of that. I talk a lot, but this morning I'm not going to talk a lot about our panelists. I'm going to ask them a question, and then the part of that question, I'm going to ask them to briefly introduce themselves and also to talk to you about why they decided to participate in this project and write this book. First, we have the president of the National Judicial College, President Dennis Aldana, who's been a long-standing friend, a highly accomplished individual. We have next to him Mr. Walter Gunclaves, and he will introduce himself. He's one of our generous authors. Next to that, Chief Anthony Holloway, whom I have on speed dial, not because I have criminal tendencies, but because he is a great friend, and we have worked together in collaboration on many projects. And then the most generous person, I believe, on the face of the earth, and a leader, prosecutor, Ms. Kim Parker. So we're going to start now by having them introduce themselves and talk a little bit about why they decided to write on this project, and tell you a little bit about their chapter. And I want to start with Kim Parker. After all, we would start with the most generous person. So Kim?
Thank you, and good morning to all of you. I think that one of the most important things that has ever happened to me is to be part of this criminal justice section, and to be part for now nearly 15 years of listening and learning from the various voices in different parts of our criminal legal system. So if you are not a member of this section today, I hope that you consider becoming one, because this is a place where you can listen, you can collaborate, you can think big, and you can find and create ways to implement the things that you want to see happen to make our system more just, more fair, more equitable. So I don't know if that's an introduction. I spent 32 some years in prosecution. I also was part of the National District Attorneys Association board for 20 years. So I know a lot about how prosecutors think. In addition to managing prosecutors in a medium-sized office in Kansas, I also know what it's like to have no people of color in your work life or your growing up life. And I think that's enough of an introduction.
Thank you. Chief Holloway?
Good morning, my name's Tony Holloway. I'm the police chief with St. Pete Police Department, which is in Florida. I've been involved with law enforcement for the past 38 years. Of that 38 years, I've been a police chief for 14. I think I'm crazy for doing it for 14 years, but I enjoy what I do. I've worked for 3 different cities as a police chief. I assume I know how to keep a job. I've just been asked by different mayors to join them to work on policing in their community. I got involved with the American Bar Association about 6 years ago, and it was a great time to be involved because that subject came up about body cameras. And when I first joined the ABA, I said, these lawyers have no idea what they're talking about. They don't want to listen to us law enforcement officers. But from that meeting, that's when I met Judge Donald, I learned so much from you, and vice versa, and I was able to carry that message back to law enforcement, and we were able to come up with a resolution to help law enforcement navigate their way through the body cameras. As far as being asked to join with writing this book, it was an honor for me. If you remember, I think a lady, Ms. Myers, when she talked about diversity, she said diversity is being asked to the dance, inclusion being asked to dance. And this book, when we started writing this book, and I was talking to my staff, it helped the last part, teaching someone how to dance. Because you can be invited to the dance, and you can be asked to dance, but if no one showed you how to dance, you're still going to sit there. But this book actually tells you step by step how you can do that dance.
Thank you, Chief. Mr. Goncalves.
Hi, good morning. I'm Walter Gonsalves. I'm an Assistant Federal Public Defender in Arizona. I've been in that office for about 7.5 years. Before that, I was an Assistant Pima County Public Defender in Tucson for about 10 years. How I got involved in writing this chapter is interesting because I actually wrote an article for the Seattle Journal for Social Justice. It was a law review article that I had written in, I think, 2019, 2019. It was published in early 2020, just before the pandemic. And the reason why I wrote that article was because I was trying to find a topic within implicit bias to learn about and write about. And I had, at that time, I had been a defender for a number of years. And when I was starting out in 2005, 2006 in Tucson and Pima County, representing clients, charged with serious felonies, and most of them were obviously minorities. I mean, we're talking about African Americans, a lot of Hispanics, and some Native Americans. The only thing that I had learned in my training when it came to issues of implicit bias, and it wasn't really even implicit bias at that time, we're talking about race issues, was when it came to Batson challenges. That was, I think about it, there was some talk, there was some interest by some training in Fourth Amendment issues and implicit bias, but it was very nascent at the time. There was really nothing happening. And I found that it was, I knew as part of the system at that time, right, as sort of a line attorney, which I still am, that the issue of implicit bias was largely ignored back then, even though there was a lot of, literature and a lot of social science on the topic. I mean, if you look at my research article, but also other chapters of the book, you'll see that there is a vast literature documenting the various sort of issues that come about in criminal justice, in prosecution and defense and judging on implicit bias and sort of the disparities that come about because of the systems that we have and the lack of education and awareness that professionals have or don't have in these systems. And so as I began to sort of have an interest in writing and, I'm sort of like have an interest in just learning these issues, I found it to be astounding. And I found it to be even more astounding that there was nothing written specifically on Hispanics or people of Latin American descent, and also Native Americans, even though there is a good body of research substantiating the fact that Latinxes, Native Americans and whatnot are also found to be at a disadvantage, less so than African Americans, but anyway, that was missing in what I found in the literature. So I wrote this article, and to my surprise, Sarah Redfield gave me a call out of the blue. She apparently is friends with the federal defender in DC, and he reached out to my office and got a hold of me and gave her my email, and we connected, we talked. I remember sitting in my twins' room. They were somewhere like some class, swim class with my wife. And I was just talking to her about this article and my interest in implicit bias and my story. And she got to know me. We didn't talk about the book, but months later, she approached me and asked, "Hey, do you want to adopt your article into a book? Into a book chapter?" And I said, "Of course. That'd be fantastic." And so we worked together and put this, the article was condensed somewhat. It's shorter than the law review article, but this particular chapter for me is really important because. I wrote another article after that, on issues of identity and public defenders and other topics in criminal law. But it's really fundamental because what I feel is important to my identity as someone of Latin American descent, as a lawyer of Latin American descent, and some of the things that I've experienced, and in some ways continue to experience in my practice, which are multiform, right? They're great and sometimes and also negative sometimes. My clients experience on a daily basis. And without having a set of tools, if a lawyer in my position, a public defender, doesn't have some of these tools that I talk about in my article and in the chapter, I'm not able to really give full justice to my client. Because there are certain things that I can do and that line attorneys can do, that public defenders can do in practice, that can really, I think, make a difference and really achieve a sense of justice and achieve justice, or at least a step closer to justice. So this article and this chapter is really sort of an extension of my intellectual curiosity on these issues, but also, maybe I can talk about this a little bit later, how I sort of thought about myself in this picture as well, because it has been important to me as a lawyer as well. I connect with my clients in a way that is different, I think, than most people because of my background as someone who was raised in Brazil and was born there actually. And today I represent a lot of people who are from abroad, who crossed the border without papers. And so this chapter addresses the tools that that I can employ and that my colleagues can employ to address issues of bias that speak to a much larger sense of justice that we're all trying to achieve. Thanks.
Thank you. And we're going to come back to those strategies in a bit. And let me at this point just offer my sincere apologies for massacring your name.
Oh, it's no problem.
I'm still working. I've gotten the speed of my speech improved. Some of the pronunciations are still there. That's the next phase I'm going to work on. I'll tell you, there's a town in Mississippi, and it's spelled Saltillo. And some people would probably call that Satia, but we in Mississippi call it Saltillo. And so, I still share that burden of not being able to get all these names right, but I'm going to work on it. Offer my apologies. I'm going to go to first names after this. President Aldana, why don't you?
Bernice, first name?
Okay, Bernice.
Hello, again, I'm Bernice Aldana, President and CEO of the National Judicial College. I've been in this position for the last 5 years. Prior to this position, I served on active duty with the United States Coast Guard for over 23 years. Served as a prosecutor and retired as the chief trial judge for the Coast Guard. And I've been active in the ABA for a long time, since I entered the legal profession as a young lawyer, and been involved in many different sections, and been in the House of Delegates and other the Commission on Racial, Ethnic, and Diversity in the profession and other commissions, and currently chair the Commission on Sexual Orientation and Gender Identity. And to this morning when I stepped in and registered, I was like, how come I've never been involved in this section? Because they're mostly criminal practice. And so, I mean, I know about it, particularly with my good friend Jamie Hawk, who's been active in this section. So maybe I can get more involved later this in my career. But I'm glad to be here to answer the first question of how I got involved in co-writing this article with Judge Reba Page, is because Judge Donald asked. Simply it. But no, I mean, you know, in criminal justice, sometimes the judiciary gets forgotten. You know, I kind of discovered that recently when we received the National Judicial College received a $1 million grant from Walmart to work on educating judges about alternative sentencing. And the reason we got this grant was because a former military judge who went to the National Judicial College and realized in criminal justice forums we forget the judge. And so part of the reason that we contributed to this book is to share what judges are learning or how they're being educated and the efforts in doing that in this arena. So we have a chapter devoted to that, or a section of the book devoted to that.
Okay, so you've all alluded to your chapters, you've talked about some of the strategies, but I want to go back again and ask people to sort of tell us a little bit more about your chapter and the central thesis of that chapter. And then after that, I'm going to come to strategies. And I'm going to go to Walter first. Kim, I'm going to start up here this time.
Yes. Narrative culture and individuation. I mean, those are the three words that are in the title of the chapter. What does all of this mean? Narrative, storytelling, I mean, that's pretty important. Culture and individuation. I mean, it's much more than that, I think. But ultimately, when I thought about those three themes, I thought about the main way that I try to humanize my clients to judges and to prosecutors and to pretrial officers and probation officers and anyone in the system. And the way to do that, that I found to be missing, was to talk about these things, not just storytelling, because that's something which it's hammered into our minds as public defenders that we have to learn how to tell stories, right? I mean, that is how you try a case, right? You tell a story of your client, you explain a story of innocence, and you try to marshal the evidence to advance that theory. But the thesis of the article, or of the book, I keep saying article, but it's a book chapter. I have to get that out of my mind. Is that without these three pillars, right, it's really hard to do that. So awareness, I think, is the first piece, that we all have to be aware that we have this bias, right? That I mean, even if I'm not thinking about it, I have these preconceived notions. As a judge was in her exercise this morning, asked you to think about, what is the gender of a secretary, or what is the race of a judge, and an airline pilot. When I go into a meeting with a client, I am going to have certain, even as a lawyer, I'm going to have certain ideas of what to expect. But the goal of all this is to try to break down these barriers. How am I able to, as a lawyer, because I carry these things with me everywhere I go, just like all of you do. The goal is how do I tear down the barriers that I have in my mind? And how do I help others in the system tear down the barriers they have in their minds? So when I present a client at sentencing, and I've submitted my sentencing memorandum to the judge, I've tried to articulate, various things about my client's life, his or her background, the reason why they became involved in the incident, a theory of sentencing, if you will. All of that has to have a narrative, right? There has to be some kind of story that I'm telling that's persuasive, because as you probably all know, that's how we get along as humans. We tell each other stories. That's how we connect as human beings. But something that I didn't see in the work of others as I was formulating my thesis was, how do I incorporate culture into all this, right? I mean, is that even appropriate? And is it appropriate in all cases? And I was thinking about the example of a client that one of our colleagues represented, and this is outlined in the chapter. It was a Native American man who has been represented by this attorney several times, and she found a way ultimately to represent him at trial and at sentencing for two different cases, where she was able to really get into his culture. He's a Tohono O'odham man in southern Arizona, And she was able to talk about some of the cultural practices that he had and practiced in her colloquy to the judge. And the way that happened was that she was able to basically take the facts of the case and connect them to that. And I think that's an interesting way of doing it. I mean, I think it's very powerful. And then individuation is really kind of the same thing. So what I found to be missing in the scholarship and in the practice was to go beyond what, just beyond the story of the client and try to introduce sort of like larger issues of culture. And I think that's the trick. It's like, you want to make your client a human being, but you also want to try to connect your client to larger ideas in the community. And I think the example that I gave in the chapter was that the facts of the case were that he was charged with possession of ammunition, and he was staying at his mother's house for a feast, and he was there because he was going to help his mother to put together this large dinner for the family. It was part of the tradition, and she was really able to get into all of that in her explanation to the court. And the client ended up getting an amazing result after that. But I think that it just shows you that we have to think outside the box with some of these issues and really get into the humanity of the client, but sort of broader issues of practices of culture. And I think that's one of the novel things that I haven't seen anywhere, and I think that the chapter contributes to. But really, I mean, this is a very practical chapter. If you read it, I talk about some of the things that we can do, that I can do when I meet my client, some of the strategies in motions practice, some of the things in Fourth Amendment motions that I think can be very effective. But I also have to credit Mark Bennett, who has done, I think, pioneering work when it comes to voir dire, when it comes to trial. And he's really a model, I think, for everybody. I think, in my view, I mean, some of his ideas have been around now for a long time, and they have influenced a lot of people, but not as much as they should, as they really can. So I think in my chapter, I'm trying to I think promote those ideas and ask judges to adopt jury instructions that define implicit bias for jurors. And to allow attorneys to conduct voir dire on implicit bias, to ask jurors if they have taken the implicit association test. Most of them have not. Maybe even ask the court to have the jurors take the implicit association test before a trial, and maybe have them talk about the experience. If they haven't taken the implicit association test, perhaps have the judge define implicit bias, and have a voir dire discussion about that. Now, of course, most cases are not going to involve a theory of defense that encompasses race, right? I mean, that's pretty, I think, fundamental. But there are some cases where race is going to play a factor, right? I mean, or it's a central part of the case, and I think in those cases, you obviously are going to be, I think, entitled to get that, that kind of jury instruction. But even if a case doesn't have to do with race, even if it's a regular, felony case, a car theft or something like that, and if you have a client that's a minority, I think it's really important to tap into some of these issues during voir dire. So my article goes through a whole bunch of things, during pretrial representation, to give the lawyers some tools to apply to his or her practice.
Thank you very much. Two things that you said, one in your opening statement and then one this time. One, you talked about invisibility with respect to certain groups, and I think Native Americans or American Indians, a group that really suffers from invisibility. Many of the studies and that groups do to talk about some of these issues, they omit or exclude Native Americans, not intentionally, they just don't do them. One of the studies that I read said that the numbers were statistically insignificant. And think about it, if you're in a statistically insignificant group, what does that say? The other point, with respect to these cultural norms, now there are going to be some judges who are going to, when you're trying to approach things and bring up cultural norms, I'm going to say that, there is an American normative culture, and that's the benchmark against which you operate, and there may be some pushback to bringing in these other dimensions of culture. What do you say to people in those situations?
Well, that's a very important question, and it's a very, it can be a very touchy subject because I think that as lawyers and as people who have been trained in the law, you know, we're not taught about culture in law school, right? I mean, unless you take a class in culture in the law, you know, I mean, you can't take classes in these issues and these topics, and a lot of lawyers, I think, have an interest in that. I mean, if you majored in anthropology as an undergraduate, or, you know, you're just intellectually curious, you know, you're going to be in tune with some of these topics. But the law, you know, is not really, you know, trying to get a cultural defense, right, into a case is not the easiest thing to do. I have a case right now where, you know, we have debated calling a cultural expert, you know, and how does culture play into, you know, this is an Asian American man who is 80 years old, and he is charged in a white-collar case. And we as lawyers have been debating, you know, the lawyers that are representing him, even we are debating how to do this and whether we should do this and how can we do this, and we need to find the right person. So I think that inherently there is, you know, like the kind of interdisciplinary, you know, studies that we see in academia there are many out there. We haven't seen the marriage of culture and the law in practice. You know, like just another example is, if I have a case involving someone who's allegedly or who's forced to carry narcotics across the border, which we see a lot in Arizona and in the Southwest, we typically want to introduce an expert in these cases to talk about the culture of violence in the border, right? I mean, it's pretty important for jurors that live in the United States to understand the fact that there is a sort of culture of violence and impunity that doesn't exist here because of the fact that, well, there exists to a certain extent, but in northern Mexico and certain parts of Latin America, there is a culture of impunity. I mean, a culture where like people are raised in these cultures where there's corruption and violence and there are drug cartels. And you can read them in newspapers and you can read them about books, but some of those things that happen in those cultures come up here. You know, there are cartels that operate in Mexico, but that have people infiltrating the system in the United States. There are members of those cartels that are here and are using and applying those cultures of violence in the United States, in large cities across the border and across the country. So I want to introduce this idea of culture into my case, and I want jurors to understand that my client was raised in this culture. You know, he was recruited as a teenager, you know, to be a part of, you know, of an organization that was committing crimes. And so I want to talk about this. I want to have an expert, and I do have an expert that does this, to come in and talk about it. And so that is a novel thing to do.
Okay. And I hope we'll get a chance to come back again, but I want to go to Bernice, because your organization is training judges. You heard Walter say that it's an issue sometimes with voir dire, and I know in the federal system, for those of you who practice, I mean, federal judges they sort of hew to the Carly Simon theory that nobody does it better than the federal judge in terms of conducting voir dire. So what do you do? What do you tell judges with respect to how inclusive, what techniques they can use to ensure justice and reduce bias, or whether to extend justice and reduce bias?
So let me start out with saying that, you know, the word implicit bias was not really in our curriculum when we started teaching implicit bias. The course is called the neuroscience of decision making, right? So we teach it from that science space because we want to make sure that everybody feels good about having a conversation.
Can the people in the back hear him?
Can you hear me? Yeah, great. And so when I was a military judge, our first implicit bias training for the military judges was in 2017. And there was a lot of pushback. Why are we doing this? This social science mumbo jumbo, right? But now it's really ingrained in part of the training, in understanding implicit bias, other biases. And of course, with what happened in the last couple of years, we examined the issue beyond just personal implicit bias or explicit bias, but looking at the system and actually saying systemic bias or systemic racism. So we recently at the National Judicial College had a course 2 weeks ago in Memphis, and it was the Anti-Racist Courtroom, Theory and Practice. Even having that title of the course, oh my gosh. thank God nobody really gave me a hard time, but, and Judge Donald was part of that course, and there were 60 judges who signed up for that course voluntarily, and court administrator, because I think there is really a strong desire, and the momentum, and hopefully sustainable, as Kim Fox said, that's a real challenge. To dig deep, not only in the biases, but our history, and we did a number of exercises, if you recall, Judge Donald, and at the end of a 5-day course, came up with specific action items that the courts can take to try to eliminate those, or reduce bias, eliminate some of those systemic issues. So at the college, we go from the basic to where a little more discomfort. I think one of our authors talked about part of this conversation has some discomfort. It can't be all just, let's make sure that everybody has safe space, which is important. But I think that there's progression in our learning. And so generally, this is I don't want to say hot topic, this is a topic that the judiciary is invested in from other organizations, whether it's the National Center for State Courts, the ABA Judicial Division, all the organizations we work with are really invested in the issue in ensuring that judges understand their bias, they're intentional about understanding that, dissecting it, recognizing it, and deciding how to address it. At the college, we have a decision-making metrics we teach judges, and this is actually a matrix that was designed by Kimberly Papillon. You probably know who she is, some of you, one of our faculty expert. And we asked judges to kind of actually go through these log process and identifying objective criteria and subjective criteria in their decision-making, and at the end of the day, examine whether or not any of those biases have been influencing their decision-making. So the college, and I think the judiciary in general, is on this topic and continue to engage in learning and conversation. So.
Okay, thank you, Bernice. Chief, we know that law enforcement is in the spotlight. People are daily, I think, critiquing, what was the phrase Kim used? Anyway, she's critiquing, people are critiquing rather the performance of police officers, and sometimes the judgment of communities is that it's falling short. There are also situations where people are, she said people are engaging in a credible critique. So I want you to talk about what strategies are you laying out in your chapter, if you will, of what law enforcement should do to reduce bias and extend justice. What's your thesis?
So we start off with the biggest thing. Can people in the back hear me? That, first if you say we're going to have a cultural diversity class in law enforcement, anyone, then you get this arm like this. That's not me, and why do I have to go to that class? But then when you come back and say we're going to have a culture awareness class, excuse me, and you want to make everybody aware of their bias, then you see more. And that's what we talk about in the chapter, about trying to identify where your bias came from. If you look at it, if you put 5 kids at the age of 5 into a playground and they're playing with each other, the first thing an adult's going to do is going to grab one of those children and say, you can't play with that child. Now that child doesn't understand that, but you've already interjected your bias into that conversation because you grabbed your child because you didn't want that child playing with that kid because maybe the race, your gender. So now the kid's going to ask you the question, why? So we know that again gets related to officers as they're growing up. We have a class when the officers first come in, again, culture awareness. And just like Judge Donald did here, is we bring them through a scenario. And the first thing, one of our first scenarios, a white female, age 24, 25, driving a nice car. Quick, what do you think? And the first thing that comes out of everyone's mouth is, her daddy gave it to her, she's got a sugar daddy. It can't be her car. It's impossible for that to be her car. And then you go on to figure out why did they get there and how did they get there. Was it from their childhood? Is it something that we're doing in training? Is it something that they're seeing on television? Because television really does help reinforce our bias. Then we go about, and I always use myself is that, I said I've been in for 38 years and I went undercover. When I went undercover, I worked in narcotics and you know, you have to dress down and everything. And I went to church every Sunday with my mom. And as I started to dress down more and more and more, she finally told me on one Sunday, she goes, baby, I love you, but don't go to church with me anymore. Because the way I started looking. Because I was trying to play a role that I thought was the right role, but in that society, my parents didn't like that. The community didn't like that. And when I found out, when I started dressing the opposite direction, guess what? I started making more drug arrests because I looked better and I got more customers. So you have to look at that perception. So we have to continue on with that is how do you reinforce that with the officers? Because they're gonna come in, just like in this room here. Everybody in this room, because of your profession, every client that you see is a negative contact. Because you're seeing them at the worst of the worst. And so is law enforcement. So when you start to make that judgment or you try to look at that person, is you have to question yourself, or what are you basing your judgment on? Is it something that you've learned, something that you perceived, or something that you know? And once you start looking at those three things, then you can identify how you're going to address either your clients or the officers. I know we're going to talk later about strategy, about how we do that at the police department, now how we do that in the Tampa Bay area, now it's how we do it in Florida. But it's just being made aware of your cultural biases. There's nothing wrong. There's no way in this room in the next 30 minutes we're going to change you. It's impossible because it's embedded into you. But it's just making yourself aware that when you're looking at that case file, are you looking at the case file or are you looking at the person? Or are you looking at the crime? And the same thing with the officers. When you're dispatching that call, are you looking at that call screen or are you looking at where am I being dispatched? What community am I going into? Because I'm going into this certain community, so I have to act a certain way. No, you're going into a community and the law says X, Y, Z. It doesn't say you shall do this in the wealthy community, you shall do this in the black community, you shall do this in the Latino community. It says you're there to enforce the law, and it should be done equally, and take your bias out of it.
Thank you. Kim, talk about your thesis. And, you know, Kim Fox said that every day prosecutors are putting justice on their shoulders and moving forward to help create a just and inclusive world. What are the strategies that you well, first of all, what are the issues that you see, and what are some of the strategies that you would put forth to try and eradicate those biases or those barriers and extend justice forward?
Thank you. I just have to say that we had a rock star keynote.
Oh, yes.
You know, bringing us all back to the place that we are, Kim certainly did this. And one of the things for prosecutors is they are in, and I think she mentioned gatekeepers, into this whole system, and of course we are. You know, you might say law enforcement, but really that's not true. It's the prosecutor's office. And if we can find ways to impact diversity in those offices, awareness as to implicit bias, but the purpose of this book is implementation. How do we implement? And I'm here to tell you, this is my salesman pitch here to you. When Kim spoke, we were thinking, or I was thinking, that's awesome, that's awesome. It's so overwhelming that we just move back to, I'm exhausted, I can't do it. But you can, every single person in this room has associations and places in their offices, in their communities, in their homes, their associations to use this. You don't have to invent the wheel. You can use this book to move forward in the implementation. Now, awareness, yes, we still have to even get that message out. But this book has, as you can tell from this group of individuals, so many different ideas. I didn't write a chapter, but Justin Bingham and I and Calvin Biggers in the federal system, we were kind of on a little panel. What would you do in your office? And first and foremost, you know, I told you already, I come from Kansas, you know, I think one of the biggest things is like, well, nobody of color or any diversity ever applied, you know? And maybe that's true. But there has to be a hiring strategy. Whether it's a prosecutor's office, law enforcement, public defender, wherever it is, there has to be an intentional hiring strategy. Because like all prosecutors, public defender's offices, etc., people are in the grind. They're just moving from one case to another. They don't have time to reflect. So the person at the top has to develop a hiring strategy that is very intentional to address diversity, biases, etc. The other thing that has to happen, and it's been set up here several times, and it works, it is the way we communicate. It's what sells products, it's what sells brands, it's what sells religion, our testimonials. Now, you may not want to hear some person in your office's biased views, but you can ask them in such a way to have them address their own experiences and listen to what they say. Our Women in Criminal Justice Task Force did that. They listened to people that they didn't want to hear maybe what they had to say, but if you don't allow them to speak and listen back, you can't change their experience. And the good news about implicit bias, the really good news is we all have it, yep. But there is, and those words are in this book, there is the ability to relearn and to change. You don't have to do it all. You don't have to resolve every solution. Kim Fox is doing that. You can pick one. Pick jury selection. Pick Batson challenges. Pick intentional hiring. Pick listening to the people you're associated with. Hear their testimonials. Give your testimonials. Whether it's they're going to tell you something of explicit bias or implicit bias. Listen and hear, because that's how we learn from one another. And when we hear it, and we hear it back, we're like, oh, we got to do something. And this is a vehicle that you can move out there for that. One final thing is training. And that is in your offices, in your places, in your communities. Training is so essential. But I have a bias that I think that training has to come from inside or from people who are like you to start. Because otherwise, they do this. And so, if you're managing an office, if you have the ability to move something forward, I think an intentional idea that you at least have part of your training coming from the inside, and then, start with. It's a big, overwhelming issue, but you got to start in your own backyard. That's a Kansas quote. I can't even say the word right now, but that's a Kansas saying. I got lots of those, but anyway, get this book. There's some bulk rates. I know this sounds like a crazy sort of sales pitch, but this book can be helpful. It has so many ideas in it, and very creative and inspiring.
Thank you, Kim. Two things. We have a number of authors. I think we have 28 or 29 all total, and some of them in this room with the contributing authors to the book who are in the room, other than the ones on stage. Stand up, please, so that we can see you. I know Major General Susan up to all over.
For this one, chapter title in here was written by Susan. Ducks pick ducks. There you go.
Okay. She mentioned testimonials, and I'm going to give one, and then I'm going to open it up for questions, but I'm going to cut off the questions when I have 10 minutes, only 10 minutes to go, because I want to give our panelists an opportunity to leave you with some strategies. You're going to get the comprehensive strategies from the book, but we're going to do some quick ones today. So, you know, I was a district judge for 15 and a half years and presided over a lot of trials. I came in being nominally committed to allowing lawyers to conduct voir dire because my predecessor suggested that I should do that, even though I was a minority in that practice on our court. But one thing that really moved me to be committed unalterably to allowing lawyers to do that was a situation where I was presiding over a criminal trial. It was a young African-American man on trial for a drug offense, and I did my comprehensive voir dire, as federal judges do, and then I allowed the prosecutor to do his, and he did a good job. And then the defense attorney stood up, and she asked the Benari the following question: how many of you know what a drug dealer looks like? Raise your hand. And every hand in the box went up. And she stood there in the well, and as she stood there in silence, and people realized what they were saying by their actions, you could see the hands slowly come down. Because in truth of fact, none of us know what a drug dealer looks like. And then I had to ask myself, had she not asked that question, would we have seated many of those people without further examination and without having them confront a stereotype, a biased stereotype that they had in their minds? Because over at the defense table was a young African-American man who looked like he stepped right out of central casting for the role of drug dealer in one of these movie or TV things you heard Chief Holloway talk about. And so there are, biases are there, as Kim said, we all have them. They can be positive or negative. They can be very harmful. And one of the things we don't talk about a lot is class bias. Kim Fox said this morning, our jails and prisons are filled with poor people and people of color. Brian Stevenson says it is better to be rich and guilty in these United States than to be poor and innocent, because you stand a better chance of perhaps escaping the consequences of your actions. Before I go to my final question for this panel, I wanted to just invite many of you out there, if you have questions, to raise them, and I'm going to cut this up. So we have about 7 minutes for questions, and then I'm going to go back to my panel and close out with their strategies. Are there any questions from the audience at this point? Any comments? Yes, sir.
My question's for Chief Holloway. I'm a federal prosecutor in LA, and I learned the most about the criminal justice system by talking to law enforcement. And one thing LAPD recently did is that this concept of pretextual traffic stops, where for a minor infraction, you can stop a car, and that's kind of a segue to see if you can lead to a search based on reasonable suspicion. They've now changed the law and says you have to have a reason for why you're conducting that pretext stop, some idea of a more serious crime, and pretextual stops have kind of decreased substantially. Do you think that model would be beneficial for the rest of the country? Because you can imagine that a lot of biases go into why law enforcement are conducting those pretextual stops.
100%. At my agency, before you make a traffic stop, you have to call a reason before the stop is made. So you can't lie. The person ran a red light. I'm stopped. They'll go to dispatch to the reason why they're stopping the car, and then the video camera comes up. So you can't make it up. So it is what it is. If you're stopping the person because they broke the law, that's fine, but you're not going to stop the person, and once I get the person, let me think of something as I'm walking up to the car. So that would stop a lot of pretextual stops.
Thank you. Any other questions before I go back to questioning the panel? Yes.
This is really
Could you stand up, please?
Yes. Good morning. Christine DeBerry from California also. I don't know, we're the talkative bunch. I'm really enjoying all of the carrots that are being offered about ways to incentivize change, and I'm wondering if in the strategy session or another part we could talk about the sticks that might exist, the things we use to set very clear boundaries about behavior we're not going to allow. So I feel those have been missing too.
Okay, so anybody want to comment now? Do you want to wait till your closing to talk about the sticks? Okay, I think they want to wait. So we got a pen in? Yes.
Hi, Bridget Hurley, I'm with Interrogating Justice. I had a question about, very similar to that one,
Okay.
actually, which is, so training on diversity and inclusion without some sort of follow-up assessment of diversity. So for example, in the traffic stops, why not have a very easy way of giving feedback for people to say, why not ask everyone who stopped? What was said during this traffic stop? What was said during this arrest? It's very hard to provide that kind of feedback, and training supposes that people want to act correctly and that they're going to do the work to get rid of their implicit biases, and I don't think that's a legitimate supposition, honestly. So exactly, sort of like sticks, but testing. What are you doing to follow up and give people opportunities to report, especially law enforcement, who are saying inappropriate things, doing inappropriate things? You know, I had that happen to me at a traffic stop, and trying to report it was impossible. There was no way. I'm an attorney, and I could not figure out how to report this. So it's, you know, what are you doing to test and follow up?
Anybody have a comment?
Okay, that's a question for me.
Okay.
So we just talked about it yesterday at our law enforcement section about the in-car cameras and body cameras. By using those cameras, not just to punish the officer or to find some disciplinary reason, is to use that for training. How do you go through those videos and look at them and say, you know what, this is a good traffic stop, so let me take this traffic stop footage and let me show it to everyone in the police department. Here's a terrible traffic stop, so let me show this to everyone in the police department to make sure that's done. So that's the best way, I think, that you're gonna have to take these traffic stops, the body cam footage, how can you use that in a positive way so the officers can reinforce what they're being taught, and if they are doing it the wrong way, then you can still show it to them and say, this is the wrong way, and how would you do this differently, and keep doing that.
And they all have audio.
Again, and we talked about it, everyone's different, so you're talking about my agency, so yes, 30 seconds, the body camera is always recording. When you turn on your lights, anything you do, it automatically goes back 30 seconds, and it records everything that happens.
So before I go to Kim, Chief, do you believe that these various civilian law enforcement review boards that are in some places in the country are an effective tool in at least aiding that dialogue and gathering information?
I do. We have it in St. Pete. So after every, we call it OOPS, Officer Professional Standards. After all the cases are reviewed, we send it to the Citizen Review Committee. They don't subpoena me, but I have to come and I have to explain the action that the officers took place. So we're seeing very good compliance because the officers know there's a process that has to be put in place. So it's not saying you did anything wrong, it's what did you do right? And if you did anything wrong, how is we as an agency can improve what we're doing?
Thank you. Kim Fox.
Sure. I'm just curious, we use data a lot, especially when we're talking about the disparities. And I think when we're trying to confront the biases that are inherent in how we do this work, the data tends to help us out. But I think one of the things that we often find as prosecutors is, well, we don't make arrests, we get what comes to us. And some of how we've shifted what we do, for example, drug arrests, right? We saw an incredible disparity in how blacks in Chicago were arrested related to others. How data, using data to pair with the training that you get, is that a helpful tool in the response that you have from your folks as well? Because I think, you know, the point is well taken that anytime you mention these disparities or implicit bias, there is the instinct to fold one's arm. But there's also the ability to say, you gotta unfold that because the data tells me that if everyone uses marijuana at the same rate and yet only blacks are being arrested, there's something in the chink here. There's a chink in the armor here. How do you use data to assist in kind of these uncomfortable conversations that people would feel are more personal versus actually systemic? How do you marry data with the discomforting conversations you must have?
So I'm one of these data people, and I drive my department crazy. So we have data every month that are given not only to the watch commanders, but to the district commander. Also, we didn't take that data, we give it to the NAACP, we give it to the ministers. So everybody sees the same data throughout the department. So we want to see those peaks and valleys. And you said it quite well, Ms. Fox, that, you know, during COVID, during COVID, every police chief and every sheriff found a way for justice reform. We did. We sat down and said, okay, we don't want to arrest for this. We want to, we call it NTA, notice to appear for this. And it's funny, it worked. Now within the last year, it's like, okay, let's forget about what we were taught. I think, and we talk about here, I think we got to make sure we keep that in place. Because the narrative is crime is going up. Crime isn't going up. It's the narrative that you want to sell. The far right and the far left are taking over the country. We need to get back in the middle. That's my speech for that. But we got to figure out, how do we use this data? How do we make sure we correct? Because sometimes we don't know why we're doing it. And by looking at the data, it actually breaks it down to each officer. I can tell you every officer where he or she makes a stop. I can tell you what type of stop they make and when they're making a stop. Is that a training issue, or how do we adjust that?
Sarah Redfield has worked so hard on this and very much wanted to be here. So the next question is going to come from her, and I'm just going to read it verbatim to you. And she says that the theme of this meeting is criminal justice next, solutions to move equity and fairness forward. The rest of the description is that the meeting focuses on programming that provides concrete solutions to incorporate equity and fairness into existing criminal justice structures. Programming that shows increasing equity and fairness does not compromise public safety. Programming that highlights the struggles and pushback faced by individuals who challenge existing criminal justice structures. It goes without saying that COVID-19 and other events of these past few years have changed the face of criminal justice, sometimes in good ways, sometimes not. It seems also clear that we won't go back to all of our old ways. She would ask you to reflect on what you've seen and highlight changes that we should work to keep as they relate to increasing inclusion and reducing bias. And she wants to start with you, Tony.
So I think what I stated earlier is that there is room for justice reform. We all have to work together, law enforcement, prosecutors, but the main people, the community, decide on where is that line and what do you want to enforce. My job, our job in law enforcement is to enforce the law that the community wants to enforce. You hear a lot of police chiefs and sheriffs say, well, we don't want to arrest our way out of this. Well, guess what? We keep trying to arrest our way out of it. We got to stop doing that. So I think, as she says, everybody getting together, everybody coming up with a solution to where that line, so to speak, is, and then how do we work from there out, not the other way around, because we're going to hear from both sides. We're going to hear from the far right and the far left, but everybody still wants people don't want crime in their community, but where is that? I just think we're just going to continue to work on where's that, so to speak, sweet spot. We're not going to make everybody happy, because if you do, then you're lying to someone, but it just, where is it? And I think it's just the people in this office, like Ms. Fox saying, you know, just don't bring prosecutors and judges together in communities. Bring in the law enforcement, bring in the community. Because when you sit down and you get in that room and you listen to everybody, they're going to say the same thing that law enforcement is saying, but they're just saying it in a way that that's what they want done. And I just think is, again, we all have it, like we took in the book, we talked about the strategies, just understand it and realize how we need to move forward with this. We can make our community safe, but at the same time, and I'm going to go with my part that I'll skip over is this, at the same time it's strategy, and I'll just say that is, and Judge was with us when we started the program, the Park, Walk, and Talk program in St. Pete. That means every officer, he or she has to get out of their car once a week, park their car, walk, and talk to the community. You can't make an arrest. You got to get out and talk to someone, because that's, every time you call an officer, that's a negative contact. But when you get out of that car, that's a positive contact. And my thing to you is, how many judges in this room, how many prosecutors in this room, how many of you get out in your community, walk with that officer, walk in that community, and see what they see? Because you're doing it negative also. Why don't you walk in that drug hole? Why don't you walk and see what they're doing? And then the officer of the community and the prosecutor then can work on how to solve a problem in that community without being biased.
And I'll tell you that fear keeps a lot of people out of some communities. But let's look at the way the system is structured and go to the prosecutor next. Kim, your comment, your response to Sarah's question.
I'm sorry, I forgot the
Okay,
question,
well,
but I do have something to say.
Okay, but and I'm going to tell you what she really wants is we've seen a lot of changes since COVID. What are the good things that we ought to keep, and then how do we make the case that keeping some of these reforms does not, in fact, negatively impact public safety?
You know, I think, and I'm back to Kim's statement, you know, collaboration, what Anthony said here, and listening, you know, getting out and talking to people and being exposed. We are all born of our experiences. If we want people's experience, if we want people to change, it's because we have to change their experience. And so we can't change our experience if we're all with our same ducks. We have to be out there, and we have to listen, and we have to see what other people see. And, you know, we were asked about sticks, and one of the things I remember is that, you know, I think inherently people do want to do good. They want to do good. I want to be a good girl. I want to be a good boy. I want to be a good dog. You know? They want to be good, and people do not respond very well to shaming. We know that. But they do respond to rewards. And I've thought a lot about training with lawyers, and I know for myself, or writing a chapter in a book, that you learn, your lawyers in your offices, your judges, they're going to learn the most if they're asked to be train on implicit bias. I want you to find out everything is and get out there, and I want you to promote this. I want you to be the star of the show. I think people respond to that sort of thing. So I think, you know, moving away from things that we've always done, we have done a lot of shaming. Shame on us. Let's find ways to reward people for looking and reflecting on their own implicit bias, which is unseen. And first of all, how can we see it in someone else if we can't see it in ourselves? So we have to think about that in response to how do we train, how do we hire, how do we expose? One of my favorite sayings, it's on my refrigerator in bold, is prejudice rarely survives proximity. It's really simple, in my mind.
Okay, thank you, Kim. Let me go to Walter next, as the defense attorney, and then I'm going to come to the judge.
So to answer Sarah's question, I mean, I think very practically about some of the good things and some of the bad things of the COVID-19 pandemic in my practice. One of the things that I'm very critical of, and I think is just something that's never going to go away, is that, you know, me included during the pandemic, we had different kinds of contacts with our clients, right, during the pandemic. I mean, I couldn't, or I could, but I didn't want to go to the facility to visit people. And we did a lot of meetings over the phone, a lot of meetings over video, and the limitations that come with that. And as the pandemic has sort of, you know, began to wind down and people began going more to the facility to visit people and meet with families, you know, in the community and in the office even, we were kind of coming back to our old ways, you know, and where we had to go to the facility to meet people, there was, you know, a limited availability to do video. But I think that some people have not gone back, that they are resistant to going back to how we used to be, which was, you know, like 95% in person and 5% over video. And some people now are like, well, it's going to be 95% in video and 5% in person. And that has become acceptable. And that's a big problem. I just don't see how, there's, I'm aware of a lot of, or some studies that talk about how just being with someone in the same room, it's just, there's like much higher percentages of, the quality of your interaction is so much richer, and there's so much more emotional connection with someone when you're sitting, in front of them, face to face. You can see their body posture, you can hear them, you can see things you're never going to perceive and experience over video. And there's something that's lost, when you're relying on not traveling the distance to a facility. And unfortunately, a lot of attorneys are doing that. They're missing the personal contact that we had during the pandemic. And I think there's a long-term impact on this. It may be marginal, but I believe that the quality of representation has decreased because of the pandemic. And I don't know, I'm hopefully I'm wrong about that. But I think there has been a very negative impact of those things in our practice. Now, some of the good things obviously are that it's much easier sometimes to, relay information to people. If I have to have a quick meeting, if I have to do something quickly, if I have to, just explain something that doesn't take very long, I can maybe get a lot more done now because I have access to all these other communication systems that weren't around before, and I can do that in my home when I'm teleworking, which I do twice a week. Those things are incredible. And so I think really the key to a more prosperous future as we move forward for the practice, my practice in my office and in other offices that I'm aware of, I know about, is to marry those two things, right? I think we need to take advantage of the things that are convenient, but also be aware of the limitations. I certainly don't want to, encourage people to do things that they don't feel comfortable doing, as far as, the in-person visits when, like we're coming across now the flu season. But on the other hand, I also want to caution people on the dangers of readapting to the past.
Thank you. Judge?
I guess I'm going to start with the stick question. So, I think we've come to the conclusion at the college that education on implicit bias should be mandatory, even though it may be resisted by some. The ABA several years ago had a resolution essentially encouraging mandatory training to all judges, and some jurisdictions took that challenge and made it mandatory. And because of that, judges were forced to confront this issue and have that training and continue that conversation. And it's not just that one-time training, but it's ongoing examination. And then the other stick, as you know, the ABA Model Code of Judicial Conduct 2.3 explicitly, specifically I had it here, forbids bias, whether actual, apparent, or explicit. And Model Code 2.3, and that's something that obviously that judges hold on to. And in fact, there's a number of cases where judges reported their colleagues for violating that particular canon. And most recently, I know in Washington that happened, and the judge resigned from her position. So that's to answer your question, that's just one. In Sarah's question, I think for the judiciary, and I'm fortunate enough to be able to attend the meetings with the Conference of Chief Justices, and that's the judicial leaders around the country. I know that the COVID has forced them to think about different ways on capturing what was learned from our experience the last couple of years, and how to use that opportunity to provide more access to justice. In fact, yesterday, many of those Chief Justices were at the Willard, I don't want to say, but the Willard, having a conversation about this topic, what they can learn in terms of whether it's building a new structure so that you can continue to accommodate remote proceedings, but also improve access. And so I think that's a positive sign. In terms of, I think I initially stated that this issue is important for the judiciary, and as Mark Bennett said, it's a threat to our justice system, but also really a threat to our democracy. And so, as a shameless plug for the college, we have an upcoming course, and this is one of our staple courses called When Justice Fails. This year, and the title is It Failing Now? And it really looks at different societal conflict throughout history and see where judges have either risen or failed in their responsibility, looking at Holocaust, the Japanese incarceration period, and other period of times. And so I encourage you to, this is normally for judges only, but I encourage you to sign up for this course if you're interested. I have some flyers here. So this is kind of our next iteration of that course, but thank you.
Thank you. I think we have 30 seconds left. Before I ask you to join me in giving our panel a round of applause, I do want to again bookend Kim and say that we do have copies of this incredible body of work here for sale. It is a $98 book, but you can get it today for $60. And we would encourage you to get this and put this in your library. You can get all of the strategies that we didn't have time to tell you about. Please join me in thanking our panel and then welcoming our leader, Justin.
Well, Judge, you actually have a few extra minutes. So I don't know if there are other questions in the room.
How many minutes do we have exactly?
We actually go to 10:45, but I see that you do have a question back there.
Hi, can you hear me?
Yes.
Hi, I'm a prosecutor in Seattle. My name is Marilla. My question is, what, if anything, are you doing with regards to addressing bias when police are responding to PD calls or sexual assault calls for victims, and addressing those biases where victims are remaining in relationships that may be frustrating even as prosecutors to us, but understanding those dynamics. So what are you doing, if anything, to address that? Yes.
Okay. Like, oh, here I go, I'm in trouble. In Florida, it's different. Florida says there's no discretion. If an officer, he or she is dispatched to a domestic, they shall write a report. If there's any sign of violence or any marks on the body, they shall make an arrest. So that's taken out, so it doesn't matter. It's everything that you shall do this, you shall do that. It's step by step what they have to do. There is no discretion in that.
And I guess it's similar in Seattle, we're a mandatory arrest state as well. I guess I meant more so the way in which the officers are interacting with the victim. So, for example, when a case comes to us, sometimes we'll have victims who will say, the officer was, not very, open to hearing what I have to say. And while he may have wrote the report and documented everything that took place and engaged in the mandatory arrest and got the probable cause, the interactions with the victims are not, I would say, so empathetic. And so that was more so my question.
So then we go back to the body cam footage. If the victim or the defense had an issue, they could file, not say a complaint, but an issue. Then it would be reviewed by the sergeant, lieutenant, the major for training purposes. And if there's still an issue that they see they violated something in a policy, then it would go to the also professional standards. Then I would become the complainant and follow up with that.
So I told Judge Donald that I actually had a question I wanted to ask Bernice about judges, because I think that one of the things that he said is very key, and that's that many times in this conversation, we sort of forget about the judges and how they play such a key role, and their biases can really change the trajectory of cases. And you sort of see that from our conversation. Many of the questions that have come from the audience have gone to Tony Holloway, because we think about biases from that very beginning stage, and once everything goes down that road. But I guess my question to Bernice is, it's something that I witnessed myself. in Spokane. Just like Kim, we're part of the MacArthur Safety and Justice Challenge. And part of that work, as part of the challenge that MacArthur has forward, is to ensure that we train the people that work within the system on implicit bias. We had a series of trainings. Everyone throughout the system was part of it. And there was one day, not long after we had our training, that one of my young interns, 3L, that was, we have a limited license to practice for interns in Washington, and she came to me and she said, you know, I remember that training last month, and I'm seeing something in the courtroom that concerns me. And it was one of our court commissioners that she had explained was clearly treating African American males different on very similar facts. And she said she thought at once it was just, you know, that particular day or that particular case, but it wasn't. It was more consistent, and it was pronounced over a period of days that she noticed it. And so she asked me, she said, will you come to court and see for yourself? Because she saw there was a couple cases that she was feeling that we would see some variances. So I went, I watched, and sure as could be, it was exactly as she had described it. And the court commissioner was short, abrupt, dismissive of the African American man, where he let whatever go with everything else that everyone else said. Where at the end of the day, it was clear that they were being probably just as loose with the facts as the other guy was. That's why he hasn't been coming to court. And so I thought about, how do I deal with this? Thankfully, I had a relationship with that court commissioner, and I knew that they were a good person, and that they probably were doing this because of implicit bias. And I talked to them. I said, I'm not going to talk to you about the facts of the case, but I'm going to talk to you about how you were dealing with the people. And the commissioner was completely mortified, and took it upon themselves to do the hard work of investigating implicit bias further, reading up on the subject, and dealing with the concerns that I brought forward. And we've not had this issue before. Now, this commissioner didn't go to the courses, and so they didn't see the training. But it made me think, what if I had not had that relationship, and I didn't feel comfortable going and talking to that judge? What's my remedy? Do I need to report? Do I need to, in my state, we can affidavit, essentially say that we don't believe we can get a fair hearing, that judge? I mean, this is a very serious issue when you have someone that makes those decisions. And so I guess I wonder if you could provide some insight into what is a best strategy for dealing with that situation.
Yeah, first of all, send them to the National Judicial College. Give them full scholarship, I'm telling you, full scholarship. I think that, confronting the issue and here where you have a relationship, I think work, because force them to self-examine and look at the issue. And I know if you don't have that relationship, it's kind of hard with the judge. Or tell the other judge to have the other judge talk to the other judge. And again, send them to the National Judicial College. But yeah, I think it starts out with recognizing, as many of us here said, we all have biases, and we have to just dissect intentionally and learn from them and see, employ strategies in dealing with them. And this book, as Kim said, is full of strategies. Part chapter is page 240. I was going to go through it, but it's right there in 240. So, right.
Thank you. And I think that Judge Donald, you're going to do a closeout, and then we will break. So,
Sure.
Mark has a
Mark, your question, please.
Thank you for a wonderful panel. My name is Mark Wojcik. I'm a professor at the University of Illinois, Chicago. I wonder if a question for Judge Bernice, is there any training available at the National Judicial College for transgender victims, witnesses, defendants?
For judges, yes. We have training for judges in order to understand issues faced by the LGBTQ community. We've been developing a model curriculum to address that. Even just basically how to address litigants in the courtrooms. So we do have that training, and we could do more. So
I want to go back to Justin's question and add my own perspective. I think that everything Ben has said is absolutely correct, but I would add the following. I think that judicial educators and just individuals ought to all commit to taking one of the IAT tests. There are many variations and lots of people have taken them. And Mark Bennett talks compellingly about how he was moved to really embrace and begin this journey of understanding the role that implicit bias plays because of his background, the work he did. He just thought, no, I can't be biased. And when he took the test, it was a result that he had to confront. And to his credit, he really started diving into it and writing. And I think Walter mentioned a point. Many people who are doing public defense work feel like because I am representing, the poor, those who otherwise have no voice, I can't be biased. But I think if we really take one of these tests and really start to be open about it, we can see that all of us have some biases, and how we deal with that can really further the cause of justice or not. And I think we ought to commit ourselves to training. Self-training by reading and taking examinations and doing videos, but also going to formal training. And then we ought to be able to make sure we can talk in small groups about this work. The other thing we need to do is when we see something, say something. And that's something that we say maybe in our small groups where we're serving to further the educational process, and that's really helpful. And then judges are in a unique position to be able to, because we are not supposed to be active participants in these proceedings, but we are supposed to be active listeners and active observers. And when we see disparities, we can't get in there and interject ourselves in the negotiation process, but when we see disparate impact time and time again, then we can ask questions. We can call behavior and say why. And I think that's an important role that we can do. We don't need to put our heads in the sand and pretend that we don't see what we see and don't know what we know. But I think those are things that judges can do to help in the justice process. Since I'm not really good on time and I have all this extra time now, I want to go and ask each of our panelists to, I want to go and ask Carla for a question. That's what I really want to do.
Good morning. Thank you, Judge.
Yeah.
I've been sitting and trying to figure out my question, so it might take a while to get to the point, but my actual question up front is, how much do strategies and trainings on implicit bias ignore the trauma and separation inherent in the legal system? And so what I mean by that is I'm a professor that focuses on gender, incarceration, and families. And so if, for example, Chief Holloway mentioned that on one occasion or one day a week, officers need to walk around the community and be seen as part of the community. But every other day of the week, they are looking for people who have allegedly committed crimes. And so on the ground, the community members view them not as part of the community, but always as individuals or law enforcement, part of the system, or prosecutors who might have taken their parent away because the law enforcement came in, the officer came in. And then the judge is the one who is responsible for sending your parent to prison. And so even with these trainings, there's this inherent conflict between let's be aware of our implicit bias, but the system itself is essentially created to separate individuals.
You can answer the question, that'll be your close.
So I say at work, when you say one day a week, it works more because if any community is a negative contact, the only time you see an officer come into your community is what you say, make an arrest and leave, then that's all they see. But now you see a mixture of the officer coming into the community and talking to the community and on and that. So our arrest rate now for homicides are 95% closure. So now people are talking to people. So you're closing out 95% of your unknown homicide. So that's where that bridge starts. So, and my ending would be, instead of waiting for, get all your ducks in a row, someone's got to go out there and cross the road anyway. So why don't you be the first to cross the road and other people will follow you.
Okay, now people have 30 seconds for their close. Kim?
I think that Carla's just kind of brought this to a place. We can talk about implicit bias, we can train about it, we can expose people, but then we still have this criminal justice system that is contrary to that, oh, that prosecutor took my parents away, that prosecutor put my son in prison, that law enforcement officer arrested him. And that is because we are built on this adversarial system. We all go to our corners and we fight, and then, prosecutor wins, right? My bigger hope is that we move from an adversarial legal system to a non-adversarial system where we can actually work with one another, collaborate with one another, deal with the many issues and traumas that face individuals in our communities, in our country, and resolve them in a different way than everybody in their fighting corner. So,
Thank you, Kim. Walter, your 30 seconds.
Yeah, thank you. This is really interesting because I'm thinking about how hard I can work, with implicit bias and training and knowledge and awareness and implementing strategies and, having an office that's like a really cutting edge implicit bias aware office. And that is increasing. I think that there is more interest among defense lawyers and public defender offices to implement some of these things in training and hiring more minority lawyers and all this. But the fact of the matter is that that can be effective and that can achieve results that we have some control over that. But as defense lawyers and even as prosecutors, there's only so much we can do about the entire system. I'm not going to talk about the entire system as my closing remark. I'm just going to say that I have seen in the last few years that I've done this work with training and writing and whatnot and talking to defense lawyers that there is more interest among people in implicit bias. I think the literature that has been published by academics and researched has eventually gradually made itself known to practitioners, and that's continuing. I think that's very optimistic and that's very positive. And there has to have, I think that there has been positive change as a result of that. So what we're doing here today, this particular book and this panel and this room, this is really the cutting edge. We are marrying social science with the practice. And what can be better than that? I think we can bring it to a bigger audience, and I think that's the next stage.
Thank you. Bernice?
I think we need to move away from just talk about implicit bias and extending justice, really looking at systemic issues. As I said in the beginning, I'm kind of actually sick and tired of talking about implicit bias. And it's something that we need to continue because there's a new generation who misunderstand it, but there's other root issues that we need to confront, and some of that is going to be painful. I learned in college, learning is suffering. You have to have some of that level of pain to grow. So as a country, we need to address that.
One of the things we're trying to do also is to try to, rather than talking about implicit bias as a standalone topic, to really infuse that into the substantive and procedural law. So when we talk about evidence, have this as a part of that. And when we talk about civil procedure and all the rules and all of that, be aware of, cognizant, and put this training in those things. Thank you so very much for being with us, staying with us, our leader, Justin Bingham.
Can we give them another